Hello and good evening, everyone. Thank you for joining us tonight, and welcome to BCCLA's Intersections of Civil Liberties panel discussion. My name is Liza Hughes, and I'm the Executive Director of the BC Civil Liberties Association. It is my absolute pleasure to moderate this panel with my wonderful colleagues, Megan McDermott, Vibert Jack, Veronica Martisius, and Ga Grant. Before we begin our event, I'd like to acknowledge that the BCCLA is based on the unceded lands of the Musqueam, Squamish, and Tsleil-Waututh. As we're all joining virtually, and some of you are joining from different territories, I invite you to take a moment to share which lands you're joining from in the chat now. Our work as a civil liberties organization often requires us to frame our arguments supporting human rights as articulated by the state, or according to state-recognized framework of laws. When we argue cases, we're often limited to considering issues through the lens of the Charter of Rights and Freedoms. But that's not the only source of our rights as people. The state of Canada is a colonial occupation of a multitude of Indigenous territories where laws and systems of governance existed prior to contact and continue to exist. Canada's laws are not the only authority that exists on these lands. So when we ask a state, which is based on oppression and genocide, to be the decider of our rights, we validate its violent monopoly on morality. In our acknowledgement of the lands that we occupy, we must also contend with the ways that the work we do at the BCCLA validates the authority of a colonial state. We encourage everyone joining us today to take a moment to consider the colonial structures in which you participate and how we can dismantle these systems. We've tried our best to have this event run smoothly and be as accessible as possible, but please forgive us if we run into any issues. We'll try to resolve them as quickly as we can. And if you have any access needs that are unmet, please feel free to write them in the chat or email us at info@bccla.org, and we'll accommodate you as needed. Before we properly introduce our panelists, I'd like to provide some background on the BCCLA. For 61 years, the BCCLA has been working towards equality, freedom, and justice and liberty. This makes the work of our organization very wide-ranging in scope, including issues from police accountability to freedom of expression. In the spirit of the BCCLA's wide range of work and the broad scope of what it means to strengthen human rights and civil liberties, the topic of this evening's panel is the intersections of civil liberties. Tonight, our panelists will speak to the BCCLA's work in 4 different issue areas. They are privacy, detention, racial profiling, and immigration. If you have questions at any point during this panel, please put them into the chat and we'll present them to our panelists when we open for questions from the public. And with that, it's my pleasure to introduce our panelists. First, we welcome BCCLA's Litigation Director, Vibert Jack. Vibert has previously worked at Prisoners Legal Services, where he worked tirelessly to defend the civil liberties and human rights of incarcerated people, who are among the most marginalized and vulnerable populations in our country. Vibert will be speaking today on privacy rights in Canada and the various ways they relate to our civil liberties. Vibert?
Thank you, Liza. Yes, so privacy, I think, has been at the core of the BCCLA's mandate since the very beginning. And yet it can be difficult sometimes to explain why privacy really matters. We often hear people say things like, if you have nothing to hide, or if you haven't done anything wrong, then what is there to worry about? But privacy violations really do intersect with many other civil liberties, as well as our personal identities in very concrete ways. when privacy is violated, that can undermine our other rights. Often it's associated with freedom of expression and freedom of association, but we can also see impacts on our equality rights and even our liberty. And we'll talk about some examples of that in a moment. Privacy violations also impact our behavior. So if you know that the state is watching you, there's always going to be a tendency to self-censor. And that can limit our participation in society and our feeling of belonging in society. And those impacts tend to disproportionately affect already marginalized groups and contributes to further marginalization. So I wanted to look at some examples of our work to kind of illustrate these problems. In the national security context, we have a case ongoing that's currently before the federal court that started as a complaint against the Canadian Security Intelligence Service, or CSIS, for illegally collecting and sharing information about Canadian citizens and groups seeking to participate in the National Energy Board's Northern Gateway project hearings. And access to information records that were released in the media suggest that the targeted organizations were viewed as potential security risks simply because they advocate for the protection of the environment. In that case, we are arguing that we're particularly concerned about the chilling effect that this type of intelligence gathering and sharing would have on participation in these types of hearings, as it appears to criminalize what is intended to be a forum for public expression and engagement in decision-making processes regarding projects of significant public interest. And we can see, again, this is a classic example where there's an intersection between privacy and freedom of expression, freedom of association, and the right to protest. Another place that privacy rights often get violated is in the criminal context. So over the last year, we intervened in a few privacy-related criminal cases. One is R.N. Bajkowicz. The decision is yet to be released, but it's a case that will determine whether Canadians have a reasonable expectation of privacy in their IP addresses. And essentially, the question in that case is whether police need to seek a search warrant to get someone's IP address, or if private companies can just hand over that type of information. And we intervened to argue that without judicial oversight, third-party private corporations have the power to displace individual agency and decide whether and when to uncover online anonymity to facilitate police investigations, thereby, in essence, expanding the powers of the state. And another group of cases that we intervened in, R.N. Romelson, Dare, Jaffer, and Hanifa. These cases dealt with the law of entrapment in online spaces. And in that case, we intervened to argue that undercover police investigations conducted in the virtual world pose unique threats to privacy and expressive freedom. State scrutiny into private and expressive activities online enhances the risk that individuals will self-censor and withdraw from online participation altogether. Further, in that case, we specifically urged the Supreme Court of Canada to affirm that these important charter interests are interconnected, and they did agree with us on that point. And finally, an area where we, I think about privacy less often, family law, a case called TL in British Columbia. In April, the BC Court of Appeal found that Section 96(1) of the Child, Family and Community Service Act violates the Charter's privacy protections due to inadequate safeguards. This provision allowed the Director of Child Protection and their social workers broad and unrestricted authority to obtain private medical information of natural parents. And in this particular case, a warrantless search of an Indigenous mother's medical records actually led to the removal of her child. We got a little bit of a shout out from the court in this one, so I just wanted to read a quick quote from the case where the court said, as aptly emphasized by the BCCLA, the search power can be used and most likely is used to inform decisions that carry the potential for far-reaching impacts on parents, children, and the parent-child relationship. Depending on the steps taken by the ministry, those decisions may lead to court-based proceedings that engage Section 7 interests, so liberty interests. From these examples, we can see that in addition to the inherent harms that are caused by invasions of privacy, there are also many very serious and often discriminatory consequences that flow directly from violations of our privacy.
Thank you so much, Vibert, for sharing your insight and for outlining the BCCLA's work in this area. Next, it's my pleasure to introduce our litigation staff counsel, Veronica Martisius. Veronica joined the BCCLA in 2019. Prior to becoming a lawyer, she spent almost a decade working on the front lines as a victims' rights advocate, court support worker, and courtroom clerk. Veronica will be speaking on the growing use of non-punitive detention under BC's Mental Health Act, and how this paternalistic approach violates fundamental human rights and fails to address mental health in a caring and compassionate way. Veronica?
Thanks for that lovely introduction, Liza. My name is Veronica. I use she, her pronouns. I am a Mohawk and a proud member of 6 Nations of the Grand River, and I'm thrilled to be back at the BCCLA. I returned in February to work in our litigation department after spending the year with my baby. In preparing for this talk, I found myself frequently distracted by the horrific and relentlessly breaking news of another sacred part of our Mother Earth engulfed in flames or flooded, and human and non-human lives lost or displaced. I found that my mind was being drawn towards thinking about how methods of state power and control connect to the global climate emergency. For instance, how detention serves to diminish the human spirit and suppress widespread recognition of and organization around our collective needs, like a healthy environment for us and the future generations to live well in. The global climate emergency, driven by predatory capitalism and its thirst for consumption and profit, directly contributes to increased migration and the deterioration of our health and well-being. With respect to the latter, whether we recognize it or not, we are all feeling the effects of living in the Anthropocene. Disconnection from your homeland or from a relationship to the land, lower food quality, exacerbation of chronic illness symptoms and allergies, higher frequency of sleep and mental disorders. Furthermore, extreme climate conditions are associated with higher rates of post-traumatic stress disorder, depression, and substance use. I don't think the fact that I struggled with this particular exercise at this time is a coincidence. I think it's precisely why we're here today, to talk about how these issues intersect in an effort to collectively mobilize and advocating for bold and comprehensive solutions for a better future. Solutions that de-center a paternalistic or the state or Western world knows best approach, and instead centers a nothing about us without us approach to law, policy, and services. On that note, I will circle back to the topic of detention, specifically non-punitive detention. Detention in this context is a tool that is used by the state to suspend an individual's liberty, either physically, for example, being held in a facility, or psychologically being forced to comply with certain rules or demands without being accused or found guilty of committing a crime. Non-punitive detention is an inherent violation of the right to life, liberty, and security of the person under Section 7 of the Charter, yet the state can exercise its power to detain people under prescribed criminal law and administrative circumstances, including lawful investigation, pretrial detention, to administer involuntary treatment under provincial mental health legislation, and for reasons under the Immigration and Refugee Protection Act. And that could, involve failing to establish your identity upon arrival in Canada because you are not able to provide sufficient documentation. Today, I will focus on non-punitive detention and involuntary treatment under BC's Mental Health Act. Section 22 of the Mental Health Act authorizes the detention and involuntary treatment, and that's often antipsychotic treatment of people who are seriously impaired by a mental disorder as defined under Section 1 of the Act. This has included people with psychiatric diagnoses, brain injuries, dementia, fetal alcohol spectrum disorder, and substance use related health issues. The Mental Health Act specifically impacts the rights of people who experience mental illness in a way that would be unimaginable if applied to other health conditions. The powers authorized by the Mental Health Act are extraordinary and affect the most fundamental human rights: the right to liberty, the right to autonomy over our body and to make our own health care decisions, which relates to security of the person, and the right to be treated equally. The Mental Health Act also authorizes police to apprehend and detain people based either on personal observations or information that was provided to police by third parties. Individuals apprehended by the police are frequently placed in handcuffs and otherwise restrained during transportation to a mental health facility. Once you're certified by a physician and involuntarily detained, mental health practitioners have legal powers to make decisions impacting your rights in three significant ways. One, being stripped of your right to consent to the prescribed treatment. The law doesn't require involuntary patients to be assessed to see whether they are capable of making treatment decisions. Involuntary patients are deemed to have consented to any form of psychiatric treatment. This approach has been justifiably criticized by health justice for reinforcing harmful stereotypes by equating having mental health problems with being incapable of participating in your own recovery. People who have been forcibly treated can be traumatized by the experience and delay or avoid seeking voluntary mental health services. Number two, being subject to the direction and discipline of the facility staff. This means that patients can be solitarily confined, mechanically restrained with straps to the bed, or otherwise punished during their time in hospital. Also, access to visitors, methods of communication, and the outdoors, having access to the outdoors, is at the discretion of staff. Number three, staff are authorized to release involuntary patients on leave in the community under limitless conditions. And I'll touch on this more during the question period. The Mental Health Act, detention under the Mental Health Act is the fastest growing form of detention in BC. Between April 2020 and March 31st, 2021, the BC Ministry of Health reported that 20,000 individuals were detained under the Mental Health Act, a number that has more than doubled in the last 14 years. Although BC does not track disaggregated or race-based data, evidence from other jurisdictions has shown that Indigenous, Black, and other racialized communities experience detention and involuntary treatment at disproportionately higher rates and are subject to higher levels of coercion while detained. This is a manifestation of how racism, colonialism, systemic discrimination, and inequality influence mental well-being and the use of state powers to essentially criminalize and dehumanize people who are suffering, rather than adopting a human rights-based approach to mental health involving the direction of resources towards the provision of a wide variety of voluntary care options. The BCCLA has been vocally critical about detention under the Mental Health Act since 1998. Back then, we opposed changes to the Act that expanded the criteria for involuntary detention. We also criticized the proposed amendments for not including a requirement that involuntary patients receive independent legal advice about their rights, including how to get legal advice and challenge their detention. Unfortunately, things have only gotten worse. In 2001, BC's Independent Provincial Mental Health Advocate Office was eliminated, despite the ombudsperson recommendation on why the office was needed. That, coupled with the absence of independent legal advice, advocacy services, and limited options for redress, has created an access to justice crisis. In 2019, the Provincial Ombudsman's Office released its report committed to change, protecting the rights of involuntary patients under the Mental Health Act, which found that hospitals fail to uphold the rights of the majority of patients. Despite the increase in the Mental Health Act detentions, the number of involuntary patients accessing their right to have their detention reviewed by the Mental Health Review Board has decreased. The Mental Health Review Board is the sole administrative safeguard in determining whether the continued deprivation of a patient's liberty is warranted under the Act. Despite the safeguard, only approximately 3% of detentions are reviewed. The BCCLA recently seized this rare opportunity to intervene in a case called AT and the Mental Health Review Board before the BC Court of Appeal to stand up for the rights of people detained under the Mental Health Act. This is a case where the Mental Health Review Board broadly interpreted the definition of a person with a mental disorder, concluding that the criteria for continued detention was met based on the belief that the patient would not follow their treatment plan if discharged, despite the patient no longer being seriously impaired at the time of the review hearing. The BCCLA argued that to avoid infringing the liberty right guaranteed under Section 7 of the Charter, the definition of a person with a mental disorder in Section 1 of the Mental Health Act must be read narrowly to include only those who are seriously impaired by a mental disorder at the time of review. To continue the detention of a vulnerable person who has committed no crime and presents no risk to the public simply because they may lack judgment or disagree with the proposed treatment is antithetical to the protections afforded by the Charter. We also argued that the broader legal context of state detention in its various forms, punitive and non-punitive, and the purpose of the Mental Health Act as articulated by the courts favors an interpretation that places primacy on individual autonomy over a paternalistic view of what may be in somebody's best interest. We felt it was important to intervene in this case because if unchecked, the review board's decision in AT could set a dangerous precedent in terms of creating a situation where people who are no longer seriously impaired by a mental disorder could find themselves indefinitely detained under the Mental Health Act. And who knows to what extent this is already happening, considering most people detained under the Act do not exercise their right to have their status reviewed. This matter was heard by the court on June 1st, 2023, and a decision is pending. You can find our factum on our website. We're hopeful that the experiences of people detained under the Mental Health Act will improve after the implementation of the new Independent Rights Advice Service. But where we can, the BCCLA will continue to leverage its resources to assist in the fight to protect rights of people who become subject to this oppressive and paternalistic system, because the solution in the absence of a better alternative is not indefinite detention under the Mental Health Act. Thank you.
Thank you so much, Veronica. Thank you for providing us with such a clear picture of the insidious nature of paternalism and detention. And next, we'll welcome our Staff Litigation Counsel, Ga Grant. Ga comes to the BCCLA with 4 years experience in legal practice serving First Nations, with a focus on Indigenous rights, litigation, and specific claims. Her approach to law finds strategic ways to use the colonial legal system as a tool for justice, practice alongside a lens of decolonial engagement. Ga will be speaking today on some of the ways racial profiling presents itself in policing and how that intersects with many of our civil liberties. Ga?
Thank you very much, Liza. So tonight I'm going to be talking about racial profiling. As you'll likely know, racial profiling is the discriminatory practice where law enforcement targets individuals because of their race, ethnicity, or national origin. Sometimes this intersects with religion as well, and that's what is informing the suspicion of a crime. This kind of discrimination usually comes from racist stereotypes that are embedded deep in the subconscious, both as in police as individuals and in the systemic choices and priorities of policing institutions. So essentially a law that looks neutral on paper can actually be a mechanism for extremely harmful discrimination and targeting by police. Two ways that this shows up in everyday policing are in street checks and what's called random traffic stops. So the BCCLA has a long history of advocating to ban the illegal and harmful practice of street checks. And if you want to learn more about this issue, you can check out the breakdown that was discussed at last year's AGM panel, which can be found on YouTube. And I think Engagement's going to put a link to that in the chat as well. Tonight, I'll be focusing on our recent work against random traffic stops. And then I'll briefly speak, if I have time, to how racial profiling is relevant when speaking about the rights and liberties of sex workers. So what are random traffic stops? This refers to the police authority to stop drivers with no requirement to actually have a specific reason for the stop. So the general guise is in the name of road safety, but they don't actually have to have a specific concern for road safety. So it's obviously an ironic name because the data shows that people being stopped are disproportionately Black people, Indigenous people, other racialized people. So you can ask yourself how random these traffic stops really are. So you might be wondering, how is this legal? Well, in Canada, we've had like actual authority that authorizes police to do this for 30 years. So in the 1990 case, R versus La Douceur, the Supreme Court of Canada decided that random traffic stops outside of a roadblock are okay. It found that even though these random traffic stops constituted arbitrary detention, which is contrary to Section 9 of the Charter, that it's okay because of the, and they're justified because of public interest and concerns for road safety. And the court only very passingly noted and dismissed a concern for racial implications at that time. But racial profiling and random traffic stops are a serious civil liberties issue for a few reasons. There's the arbitrary detention issue, Section 9. When there's no actual reason for the stop, it's arbitrary. But there's also Section 7 of the Charter and the liberty and security of the person interests. So these interests are engaged when people are frequently being subject to these road stops, which come with the threat of police interactions and potential criminalization whenever they're just trying to get to their destination. And thirdly, there's equality interests under Section 15 of the Charter. Obviously, race is the driving factor for these disproportionate rates of random traffic stops. And there's really complex layers of psychological, social, and economic harms that flow from it. But fortunately, there's hope that these stops will finally be stopped. In 2022, the Quebec Superior Court released its decision in Luamba, and the court found that these random traffic stops are unjustified government intrusion into each of those three civil liberties. Essentially, the law itself, which seems very neutral on paper, was, in the words of the court, perverted by the unconscious bias of police officers, and therefore became a mechanism for racial profiling. The law has no safeguards. It's just arbitrary and unfiltered. And because of that, racial profiling becomes insidious, doesn't leave a trace. So the court found that as a society, because back in 1990, we didn't have that, common understanding of racial profiling, it could overturn that decision in La Douceur. So the court found that also there was no data or rational connection to show that random traffic stops actually improve road safety. There are more proportional means for police to address road safety than random traffic stops. So what is the BCCLA doing about it? So right now, the province of Quebec has appealed the decision from the Superior Court decision to the Court of Appeal. So that's why we're applying to intervene in this very important case. And the Court of Appeal will hold a hearing to determine whether we can intervene in September. We believe it's essential that this Superior Court ruling is upheld so that we can ensure that random traffic stops are removed from police authority across Canada. We are very hopeful that we'll be granted intervener status in this case, which will have implications for the future of equality and civil liberties law more broadly as well. So I just wanted to take a minute or two here to discuss also how racial profiling relates to sex work. Because racial profiling spreads into all areas of policing, this includes the enforcement of unconstitutional sex work laws. Sex work itself is, of course, a civil liberties issue because the importance of bodily autonomy and agency over one's body, as well as life, liberty, and security of the person, which are all protected under Section 7 of the Charter. So in 2013, the Supreme Court of Canada released its decision in Bedford, and it found that by criminalizing essential aspects of sex work, it's unconstitutional because it has the impact of making sex work more dangerous for sex workers who are already subject to stigma and violence. Unfortunately, the federal government then created a new legislative regime that perpetuates these harms. So I wanted to talk about this case as another example of how we have to apply an intersectional lens, because sex work law might look like neutral, like it applies to everyone on paper, but certain groups are more subject to policing around sex work, and that includes racialized trans sex workers, street-based sex workers, as well as migrants who are racially profiled in general. They're also more likely to be policed for sex work. I think it's a bit less commonly known if you are not a migrant, but on all migrant visas, there's an explicit prohibition against many forms of sex work, even those that are fully legal for other Canadians, like working at a strip club. So essentially, if you breach that condition, you'll lose your right as a migrant and you'll be deported. So broad sex trafficking laws also permit police to have extra targeting on these populations, on migrant populations, making them frequently subject to police raids, for example, on their working environments. So sex workers of color can essentially be racial profiled for being victims of sex trafficking as well, and can frequently be less seen by police as engaging in sex work for their own agency. So the targeting by law enforcement again forces them into less safe and more isolated conditions, so affecting their Section 7 rights. So the BCCLA participated in the constitutional challenge, the trial that was this past fall, challenging the new legislative regime that the Canadian government has put forward. And this case was brought by the Canadian Alliance for Sex Work Law Reform. And BCCLA participated as an intervener. And we argued that the Section 7 Charter analysis has to be intersectional. It has to reflect the on-the-ground experience of sex workers, which includes all of their identities and the way that racial profiling and discrimination is being enacted with the laws. And this includes an assessment of the complex intersections of individual identity, social circumstances like gender, race, and disability. And our factum from that case is on our website as well. Thank you very much.
Thank you, Ga, for providing that thorough background on racial profiling. And lastly, I'd like to introduce BCCLA's Policy Director, Megan McDermott. Megan has been a valuable member of the BCCLA team since March of 2017. When she isn't working, Megan can usually be found gardening or exploring the city with her dogs. And I can say there are more than a few dog people here at the BCCLA. Megan will be speaking today on BCCLA's work surrounding immigration and how rights around immigration are, at their core, issues of civil liberties. And I'll pass it over to you now, Megan.
Thank you, Liza. Thank you, God, too, because I think what you just said about racial profiling is really apparent when we look at a lot of the issues around immigration and migration and Canada's approach to people who are not citizens of this country. Migration itself is a core characteristic of our human species. It's crucial that our laws and our policy accommodate and enable this basic activity of ours. Unfortunately, our country is not doing as well as it could be in upholding this basic human right to move around on our beautiful planet. So consider how important migration within Canada is for us. We mobilize within and across municipal, provincial, territorial boundaries all the time to see loved ones, to work, to study, to learn more, to gain knowledge, to attend important life and cultural events, to have fun, or to seek healthcare. There are so many reasons that we do this. And for many of us, the COVID-19 pandemic was the first time that we faced restrictions on this movement. Where we could go, when, this all became really important to all of us. Sometimes we were barred from entire provinces. People couldn't return home to go to a family funeral or to meet a new relative who was born. And even sometimes we saw police checks set up in between cities or between health regions here in BC. And I bet most of us still have, if we did get vaccines, our vaccine passports in our wallets, just in case, because it was so important to us in our daily activities. So now step back and consider that these same kind of restrictions still exist, but they exist internationally. And for the most part, they're completely untethered from any significant risk to human health or safety. Given our current political organization on the planet, which is that we're separated into different nation states, and each nation state is seen to have its own sovereignty to make rules, we have this international border system, which is really very discriminatory, and in which some of us have a lot of advantages over others, and simply by virtue of where we've been born or other characteristics that we may have, such as race, religion, wealth, education, gender, etc. So from a human rights and civil liberties perspective, migration laws can be extremely problematic because of these massive inequalities that aren't linked to what us lawyers, especially when we think about rights in Canada, would think are legitimate objectives. So some of us have a lot of rights, and as we just heard, migrants, sex workers, for instance, don't have, in that case, they don't have the same right. So it's an incredibly large and complex issue. So what I'm going to do is I'm going to zero in on a few of the issues that are really alive right now in our country, that we're not necessarily leading, but that we support certainly, and which I encourage everybody watching here to take part in and support as much as you can. So one issue is about undocumented people in Canada. The Migrant Rights Network estimates that there's 500,000 people that live amongst us and that arrived in our country with status, and then for various reasons, their status would have ended, and they face a really difficult decision of returning to some really incredibly difficult situations. Sometimes it's war, oppression, all different issues that these people face. And so we have 500,000 of these people that live amongst us, have relationships and have needs, but yet because they are undocumented or don't have status, they're unable to seek basic services that we can. Just think even of, if you, like going to the hospital or to a doctor, seeking healthcare was so important to us. Accessing education, if we have children that want to access education. And all of these issues are really, really hard for so many people in our country. So there's a regularization campaign going on right now. And just if you type that in to Google, there's so many great advocacy groups pushing for this, and it would make a massive difference to so many people that live amongst us. Another thing, and this is something that BCCLA has campaigned on, and it's about for those folks with status, so they aren't undocumented, but their rights still aren't the same as those of us who are citizens at least. And that has to do with voting rights. For the past few years, we've been supporting grassroots campaigners. There are a lot of people here as permanent residents that intend to stay and that would very much like to vote. And they've been asking simply just to even be able to vote at the municipal level, to vote for our mayors, to vote for the people that are on school districts, police boards, have some kind of influence over waste management and water treatment. And even at that level, so far, Canada hasn't been willing to enable, to enfranchise them to join us in our democratic deliberations. We did see a private members bill appear this year in the BC legislature, so that does give us hope, and we'll continue to advocate for those voting rights. And then the last thing that I want to point on is a recent lawsuit that was filed. We're not involved in this, but it just hit the news recently. And I know there's been a lot of outpouring of support to provide asylum and safety for people that have fled the war and violence that's happening in Ukraine. However, this really brings the stark realization of perhaps racial profiling at the border, because what we've seen is a lawsuit's been filed by Afghan Canadian military advisors saying that the federal program for the Ukrainians is discriminatory. They aren't seeking to shut down that program for the Ukrainians. Instead, what they are saying is, look, there are more people on this planet that should similarly be eligible, and it's not fair for you to not allow these other people to have the same rights as the people from Ukraine to come and seek asylum and safety while their homelands are under threat. And I'll end that now, and I look forward to talking more about our work, particularly around immigration detention, that I think will come up in the questions and answers.
Thank you so much, Megan. Thank you for breaking down that issue and giving us a thorough analysis of how immigration rights are an issue of civil liberties. And thank you to all of our panelists for helping us to understand these important issues and describing how they relate to our broader human rights and civil liberties. We're now going to move into the question and answer portion of the panel, and I'd like to direct the first question to Megan and Veronica. Immigration and detention are two issue areas that most obviously and recently intersect in the campaign to end immigration detention on a federal level. Could you elaborate on this work? How do these issues relate to immigration detention on a larger scale? And what are people's options if they want to support this campaign and push back against immigration detention?
All right, I'm going to go for it. I'm sorry, we hadn't coordinated who was going to speak first. Something that I didn't know before my work with BCCLA, and even after I joined this organization, was that I didn't know, well, I knew that we had immigration detention in Canada, particularly because, you know, under the Trump administration, it seemed there was a lot of talk and awareness about what was happening to migrant families trying to get into the United States. And then, it was made clear that, oh, we have these immigration holding centers here in Canada. Well, it's worse than that. And here's the thing that's really bad is that we do have some immigration holding centers, though, and they aren't prisons, although they have probably a lot of things in common with them. Definitely the deprivation of liberty being the starkest example of that. However, the conditions of detention can vary widely within and amongst, like from mental health detention to prison detention, solitary confinement. There's different conditions of detention that the state can use with people. So with immigrants, something that was brought to our attention, and then that we joined the fight to try to end. And this is hopefully a good news story because things are happening, is that the provinces have been complicit with human rights violations with the federal government. So what happens in Canada is that we have the Canadian Border Services Agency, and they've got the mandate to, they're the people that do the customs laws for us citizens who just come and go, and they might want to check our goods and have us pay some duty on it. But for people that don't have citizenship rights, the CBSA officers have a lot of discretion under the Immigration and Refugee Protection Act to do searches and seizures, but also to detain. So they can choose at any time that it's worth detaining somebody. And this is detention not for a criminal reason, not for a mental health reason, not because they pose a risk of harm to self or others. It's because, for the most part, statistically, it's that they're considered a flight risk. And that just means that the person might not show up for a hearing. It doesn't mean that they're just going to disappear. It just means that they might not show up for a hearing. So when this happens, the provinces have had these agreements now for years that will use our provincial prisons to detain migrants in. And that there's absolutely no oversight provided over, first of all, the decision to detain them. And then secondly, once they end up in a provincial prison facility, there's no oversight either. So some people end up in these provincial prisons. They can end up in there for years on end. People have ended their lives. A lot of these people don't even speak English. So they can't even understand the directions being told to them. So it's a really horrific violation of human rights standards. I mean, even just from the first decision to detain them in a prison, that violates so many international standards that Canada has signed on to. So that just should not even be happening in the first place. So what we did about a year ago at this time was we were working with a whole bunch of advocates, immigration advocates, people who provide a lot of services to migrants too, and those seeking asylum in Canada, because there are a lot of alternatives. That it's called alternatives to detention. Basically, there are a lot of ways that people can be housed and accommodated in our communities, and we don't need to see the federal government giving hundreds of dollars per person per day to the provinces. And so we asked the BC minister to end this contract last year. At right around this time, almost a year ago, we were at Vancouver City Council asking the councillors, and they all reached consensus and approved a motion to demand that BC end the agreement, and furthermore work with all the other premiers to end their agreement. So I'm really happy to say that we had a lot of success. Our Solicitor General made the announcement last July. That was that they were the first ones to break in these arrangements with the federal government. And since then, we've seen almost every single other province follow suit. Just this past week, Quebec and New Brunswick announced that they're canceling the agreements. It takes 1 year for them to come into effect. So we'll definitely be monitoring this to make sure it actually happens. And so BC has right until the end of July until no more migrants will be in our prisons, and we can sleep slightly better at night that one less horror will be happening on these lands. Well, actually, what I can share is that Ontario has yet to break the agreement. So if there's anybody here with connections in Ontario that's watching us, tell that government to join the rest of the pack and to stop being complicit with these violations. And furthermore, ask Justin Trudeau and his government to stop detaining migrants altogether.
Thanks, Megan. Thanks for sharing that very crucial victory. I think what I would just add to this conversation in terms of the intersections between immigration, detention, the criminal justice system, that these are all systems of that involve segregation and detention, and they link back to the foundations of this country and back to contact when the colonial occupier, Canada, had imposed various systems to control certain populations, Indigenous peoples in particular, seen that through the residential school system. At one point, there was a pass system under Sir John A. Macdonald that wasn't even a law on the books, where people living on reserve had to get a pass to leave. Now we've got Indigenous people overrepresented in the criminal legal system, accused persons, and people who are incarcerated. This is a long-standing problem that only seems to be getting worse. Our articling student, Sophia Hamed, wrote an excellent two-part blog series on Canada's mass incarceration that you can read on our website that talks about findings from the 2021-2022 report from the Office of the Correctional Investigator. In that blog, there's a number of stats pertaining to the over-incarceration of Indigenous people, as well as the over-representation of Black people in the Canadian prison system. So yeah, these acts, the Immigration Refugee Protection Act, the Indian Act, so many of these laws are imposed methods of power and control. And they are also manifestations of white supremacy on these lands as well, too. And we have to keep that in the forefront, I think, when we're doing our advocacy work. So that's all I've got to contribute at this point. So thanks again, Megan, for sharing some ways people can get involved.
Thank you both, Megan and Veronica. This issue is so important. And I think we really have a responsibility to understand what's happening in the immigration detention regime. I think the more that people understand the system, the more likely they are to oppose it. The next question is on the effects of privacy violations, and we'll be directing this question to Veronica and Vibert. What are the potential consequences of privacy violations on our liberty rights? Veronica and Vibert.
Thanks, Liza. I'll jump in. When a group is constantly scrutinized by the state, that obviously will lead to more interactions with law enforcement and all the negative outcomes that come along with that. So more detentions, more arrests, more convictions, and that all contributes to the overrepresentation of Black and Indigenous people that we see in the criminal justice system that Veronica was just talking about. By over-surveilling and over-policing certain groups, the state essentially guarantees that those groups will be disproportionately detained for various reasons. And then this outcome that these people from these groups are detained more is then used to justify the continued surveillance of the group, leading to a vicious cycle. And I think that really underscores the importance of cases like Bajkovic and Ramelson that I talked about earlier, where online privacy is at stake. With so much of our lives spent online and the number of interactions happening there every moment of every day, oversight and accountability for the police is critical to prevent them from targeting their online surveillance at vulnerable groups. Technology is just making it easier and easier for surveillance to be finally targeted, and so privacy rights are becoming all the more important. But I also don't want to leave the impression that these problems only impact some segments of society. Privacy rights violations harm all of us. Earlier this year, after a very long legal battle, we were able to release almost 5,000 pages detailing the inner workings of the Canadian Security Establishment, or CSE, which is Canada's cybersecurity body. And among the revelations uncovered by those documents, we now know that, at least at the time the documents were created, CSE had a very expansive and expanding metadata surveillance program in place, and that they were indiscriminately collecting huge amounts of information entering and leaving Canada. And we can only assume that this program has grown in the meantime. And we also learned that CSE violated even its own rules by sharing Canadians' private information with its Five Eyes partners, meaning the US, UK, New Zealand, and Australia, without properly redacting that information. And that was over a 5-year period. And we also know the CSE then took no action when it learned that those partners weren't properly safeguarding that information. So if you don't trust Canada with your information, I think we should be even more concerned when it's being indiscriminately given to other countries. And this type of overbroad information gathering puts all of us at risk for the types of harms that I just outlined. Veronica.
Thanks, Vibert. Drawing from my earlier presentation, I'll just comment on how detention and surveillance go hand in hand within the context of involuntary detention under the Mental Health Act. As I mentioned before, the Act under Section 37 empowers staff to authorize the release of involuntary patients on leave in the community under limitless conditions. So, that may seem like a better option than being detained in a facility, but patients still have no choice but to follow the prescribed treatment plan and follow any other conditions that are stipulated. And when patients are on leave, they're generally under the supervision of a mental health team. And like I said, they're still subject to the deemed consent model. If someone is suspected of violating their conditions of leave, they can be recalled back to the mental health facility. And that was the case for an individual in a case called KA in the Mental Health Review Board, which is a decision that you can read online. And it was a good decision that was released back in the fall that provides some good instruction to the Mental Health Review Board about the criteria that they're supposed to assess in determining whether somebody should continue to be detained under the Mental Health Act. And it was emphasized in that decision that, that decision should, when considering if somebody has a mental health disorder, that the definition in the Act includes that disorder be seriously impairing. So that's a really important piece in that review process that needs to be interpreted narrowly in order not to restrict liberty beyond what is necessary. So that's what I have to share. Thank you.
Thank you for explaining this important intersection, Veronica and Vibert, and for outlining the connection between privacy and detention. This is a really great example of how individual liberties like privacy rights connect with human rights and the right to be free from discrimination. So building off the last question, when we speak about targeted surveillance, what factors contribute to targeted surveillance? And more specifically, what justifications are given for this kind of surveillance? And are there any accountability measures currently in place? This question can go to Vibert and Ga.
Yeah, so I'll start with the justifications that are given. So we can look at, for instance, national security. You think about the targeting of Muslim communities after 9/11. We can talk about public safety, So as Guy was talking about earlier, street checks and random traffic stops. The right against arbitrary detention is the kind of the main right that we think about in those cases, but there is also a privacy element to it. Economic interests, another justification. So the RCMP targeting Indigenous land and water defenders who are opposing pipelines and deforestation. And child protection is another example, like the TL case that I spoke about earlier, where a child was taken from their Indigenous mother. So those are the reasons that are given, and it's hard to argue with those goals. But I think we need to look deeper and look at the unstated reasons that surveillance gets targeted at certain groups. And the common thread in the examples that I just gave is race and racism. We see over and over systemic racism leading to the over-surveillance of racialized groups. Racism informs and influences discretionary decisions around surveillance. So who to target, what information to look for, and where to focus in your analysis once you've collected information. And discriminatory beliefs lead to excessive intrusions into the privacy of certain groups, which then leads to inequitable outcomes for those groups. And that cycle really undermines the ability of marginalized individuals to fully participate in society. It creates a feeling of being excluded from the broader community. In terms of accountability, I think it's really impossible to expect organizations that are that have systemic racism in them and are acting on it to deal with that issue themselves. As an example of trying to find accountability in these cases, I talked about the complaint that we made about CSIS surveilling groups around the National Energy Board hearings. And at the same time, we filed a complaint against the RCMP for the same thing. And that was back in 2014. So the CSIS case is ongoing. The RCMP case wrapped up just last year. And in that case, the RCMP essentially just ignored the results of the complaint process for years. And we had to go to court in order to get them to even respond to the initial findings. So given the amount of time that it takes to find accountability in these areas, I think that it's safe to say that the accountability measures that are in place are inadequate, to say the least.
Thanks, Vibert, and to my colleagues who also spoke about privacy and these intersections. I think it's a really good explanation. Hopefully I'm not going to repeat anything, because if the state's surveillance is like a viewfinder, what is going to influence what they put in that viewfinder? Their racism will influence what's going to go in that viewfinder. If the interests of the state, which is in my view, to fundamentally stay the same, to not change its systems in this colonial state, then who is other to that? Whose voices are challenging whether those interests are staying the same or not, and keeping those interests safe? I'd also like to look at the TL case in a bit more depth, as I think it's a good example to contextualize the equality and privacy dimensions of these justifications and lack of accountability measures that we frequently see with these surveillance systems. So Vibert, you spoke a bit about the TL case earlier. To jog people's memories, this case deals with the ability of the director of the Ministry of Family and Child Services and social workers, the ability to access broad, unrestricted medical information on parents without appropriate checks and balances. And we're grateful that the court made the right decision in this case and found that this regime is unconstitutional because it lacks the appropriate safeguards like notice and oversight. We have long known that the child welfare system has a discriminatory eye, and it's really deeply built into the system. And that eye particularly focuses on Indigenous people, as well as those people experiencing poverty and people with disabilities and mental health conditions. Instead of supporting those people, it targets them for surveillance because they're struggling from marginalization by the state. And instead of supporting them, it targets the surveillance on them. So when we're only talking about privacy in the abstract, and the state says, but we need this information on parents in order to make decisions about child welfare and safety, obviously that sounds like a very important justification. And obviously we are very concerned about protecting children. But I think it's really important to understand that over surveillance and surveillance of this nature actually has impacts that go against these justifications. So it was part of arguments in the court that our arguments that people are less likely to seek voluntary care for their family, for their mental health. They're less likely to seek the medical care that they need now, which will actually protect the health of their family, because now they're afraid about their medical records being used against them and not having that kind of confidence with the medical team that they need. So it's when we understand who is being targeted, the racist, ableist, etc. assumptions that go into these acts of surveillance and the decisions to monitor and intervene in a family. And 3, the disproportionate impacts on Indigenous people and other groups. And of course, intervening in the family goes beyond just the family, which is a very important Section 7 interest, but it also affects culture and language and continuity of people. So that's when we really understand how problematic privacy intrusions can be, that goes so far beyond the scope of the name of the justification. And the last thing I want to say on this is that the way our state functions, in my view, it presents surveillance and privacy intrusions generally as justified, because it presents it as the only way that we can get this information in order to get this information to keep us safe. But there are other ways, and I really think we have to challenge this fundamental premise and justification as a whole, because I think we should all question whether a state that functioned on actual support and consent in all areas of society and equality in all areas of society would actually need to conduct this kind of surveillance like what we're seeing today. Thank you.
Thank you so much, Guy and Vibert. That was very powerful. Guy, you've spoken about racial profiling in the context of issues such as sex work and policing. Could you and Megan please speak to how racial profiling affects things like immigration? Does racial profiling present differently in this area?
I'll go first if that's okay. I think that it all stems from similar systemic issues, stereotypes, inequality, and I think it operates really similarly at each step of the criminal or immigration interactions. And this intersection between criminal law and immigration law is referred to as crimmigration. There's a whole area of crimmigration law. Immigration and racial profiling come up in everyday policing interactions, not just at the border, because contact with police always represents a risk for migrants on visas. Megan spoke a little bit about this earlier. And people who are on visas could be deported if they're found to commit even petty crimes, which obviously is a different level of consequence than citizens that we have. So whenever police have an interaction with a migrant, they can just look them up in the database to see if there's an immigration warrant for them. And if so, they can turn them over to the CBSA and immigration detention, as we're also intersecting here, and then deportation. So there are definitely intersections there. I think it's also really concerning the police practice of what's called a status check. So police are not required to do status checks on people, but ATIP data, like Freedom of Information data, shows that it's thousands and thousands of voluntary calls police make a year. So on the mere basis of a suspicion that someone may not have status in Canada, they can just make a call to CBSA to do a status check on them. And only requiring a discretionary suspicion or hunch that someone may not have legal status, like what we talked about with traffic stops, is just a ripe situation for racial profiling, because it's just about whether a police officer thinks someone looks like someone who might not be here without status. With respect to the immigration process, I think it's, again, very similar at each step. So I also want to talk about how this relates to our intervention in the case that it's a constitutional challenge to the Safe Third Country Agreement, STCA for short. This is an agreement between Canada and the United States, which says that any refugee or migrant that comes to Canada who already went through the US will be returned to the US on the concept that the US was already a safe country, so they should just stay there. That's the concept. But the issue is that the US is not safe for so many people. In particular, with respect to racial profiling, Black people experience an extraordinary amount of racism in the US, and we see it at each stage of the immigration process. So under the Safe Third Country Agreement, the people we're sending back to the US can be completely denied access to the refugee process if the screening authorities put them into what's called the expedited removal deportation process. And this often happens. And so they do an initial interview, and studies have shown that so many violations happen at that initial interview. In particular, Black asylum seekers are more frequently deemed not credible during these interviews. So they are deported at greater rates than other nationalities, and that's in proportion to their own makeup of refugees generally. And also the US fails to provide interpretation for many African languages. So at that first stage, we're already seeing racial profiling. And Black refugee claimants are sent back, who are sent back to the US under the Safe Third Country Agreement, also face a higher risk of prolonged and arbitrary detention in conditions that violate international norms. We have the studies on that, and they're 6 times more likely to be sent to solitary confinement in the US than other detained populations. And this goes on and on at each step of the immigration process there. So in conclusion, we have to take accountability for our own systemic racism here in Canada, but also what it means to be knowingly turning away people to another racist system under the STCA. So actually the decision from the Supreme Court of Canada in this case is scheduled to be released tomorrow morning. So we're very anxious for this and the possibility that the court may find that this agreement is unconstitutional. So we continue to see very tragic outcomes because the STCA has actually been expanded by the government to include land crossings, and they took action recently to close the crossing at Roxham Road in Quebec, and sadly more people are resorting to more dangerous ways to cross, and there's loss of life because of that. So yeah, that's the the picture of how these relate. Thank you.
Hi, I can add a little bit to this. If I can just pull up my notes. Thank you so much, Ga. I guess what I can add is that one problem with even detecting issues of systemic racism in these systems, in our border control system and in the CBSA decisions, it has to do with the data itself. And only now are we seeing some public initiatives, such as BC's Anti-Racism Data Act. And there's a provision in this oversight bill called C20 that is going to start looking at the ethnicity of the people filing complaints against the CBSA and the RCMP if the bill passes. But really, we don't have a lot of information there's not a lot of transparency from these institutions themselves about just how structurally racist their decisions or their exercise of discretion may be. I remember even a few years ago when we asked the RCMP about street checks data, and this is just kind of how quickly the thinking is changing on it. They said with a straight face to us that they don't collect data about race because they're not racist. It was that kind of we don't see color kind of thing. So we're starting to see some initiatives, not to say that they're always safe though, because I mean, we've got to make sure that these initiatives are built well and protects the safety and even anonymity of certain people. But, like CBSA has started to report out on, how many secondary inspections. That's a typical way that racism works at the border, is people getting just checked for further or more inspections. You can ask people and hear the anecdotes and start picking up on the patterns of who is subject to the secondary inspections. And the device searches, again, this is where privacy enters the world of surveillance and impacts on people. Right now, as it stands, unless this bill from the Senate called S Senate 7, which is actually pretty good, it's actually going to put in a legal threshold for searches at the border under the Customs Act. Right now, the CBSA can search absolutely anything. It's just any of the records on your phone or electronic devices, laptops, are considered to be like a pair of shoes in your trunk. So we've got data about how many travelers have their privacy intruded upon, but we don't have any other data about them. And again, we can ask questions because we can even see when bills like this move through the Senate, it's really clear which senators care about this issue and which don't. Again, because I think of the white supremacy that can flow through so many of our government institutions. Yeah, I have a baby crying in the background, so I think I'll end on that note.
Thank you. Thank you to all of our panelists for speaking to these complex issues and for making the connections between our work so clear. It helps us to understand what we're talking about when we say systemic issues and what that really means. I'm really proud of our lawyers for working to expose that system and make it visible. Now we're moving to our next section here. We're going to move on to answer the questions from our audience here. I'm going to give a moment for people to add questions in the chat if they like, and there are a few that have come through already. So let's see here. This question, okay, this one could be for, I'll let anyone who wants to jump in on this, but if no one's quick to pick it up, I'm going to choose one of you. The BCCLA has a wide mandate. Could you speak to some particular themes that you believe will or should be at the heart of BCCLA focus over the next couple of years?
I feel particularly strongly about our strategic plan in terms of supporting Indigenous rights and self-determination. Especially as I mentioned earlier, we are living during a very challenging time in terms of the ecological collapse and environmental degradation that we are witnessing all across the world, and it's often Indigenous peoples who are on the front lines and our best shot at turning things around. And so much of our work deals with laws that impact people, and we're looking at how is the state treating its citizens, treating non-citizens, treating all of the people who happen to be here on these lands. And it really goes back to, it's no surprise that people are treated poorly when we are in a country that was established through the genocide, attempted genocide. Genocidal practices are still ongoing. We have crisis of missing and murdered Indigenous women and girls. Like mentioned before, the over-incarceration of Indigenous people, the over-representation of Indigenous children in the child welfare system. Like this is not a coincidence, and really, I truly think that that needs to be at the heart of our work, because that really is the root of why we see laws and systems treating other people, the racialized people, marginalized people, the way we are seeing. And yeah, so that's what I think anyway. Anyone else?
That was so well said, Veronica. Thank you. Did anyone else want to weigh in before we go to the next question? Okay. This question is for Megan. Has the federal government ever provided justification for the preferential treatment of Ukrainians over other refugees? It seems that even from a safe third country like Germany, they could come to Canada and get financial supports and privileges and skip the queue in joining Canadian family members.
I can say that, no, I'm sorry, I haven't heard any justification from the Canadian government. And I think really that's what's really exciting about this lawsuit is that it's going to require them to provide a rationale for this. Because I mean, there are a lot of people around the world suffering, like dearly, dearly suffering. There's a lot of like civil strife happening on a lot of continents. There are a lot of people that would love to have access to the Canadian economy and safety and the rule of law that we have. So yeah, no, I mean, these are the kind of programs that when they're announced with a lot of fanfare, and it's seen as being welcoming and a good thing to do, but it's hard not to, connect the dots and think about the creation of this country of Canada and who it was for, and then slowly how the rings of who it was for has been opened up to more and more Europeans. And, again, and just that, who's left behind in this, and that if we would just want our governments to be principled and consistent in how they recognize human rights and people's access to asylum and refugee status. So no, I know I'm speculating a lot, but I really look forward to the government's response, because I think a lot of us will be looking for some truth bombs, really. I mean, they really should. They'll probably dress it up in some other rationales, but it's hard not to suspect that it's part of this idea that, Canada's just what apparently our head of state is the head of a state over in Europe. So that we see ourselves as a European colony. So I don't know, in Europe, Ukraine's part of Europe. So again, it's just my own speculation, but from the way that we see a lot of these institutions work and the assumptions that are built into it, I just look forward to the response at the court so that they can prove me wrong.
Thank you, Megan. So we're getting towards the end of our evening here. So we have just one more question here. This question here, what kind of help can Canadian citizens get when crossing into the US and being subjected to interrogation, search, and temporary detention? Anyone want to jump in on that?
I can say that I definitely have no idea about if or how anybody could help us if we were detained by the Customs and Border Patrol on American soil. But I do know from our work on the Pre-Clearance Act, which has to do with, that's where sometimes we can go through the Customs and Border Patrol in Canadian airports, and the Americans are set up there. And it's almost treated as if we're on American soil then. And what I know from our work with that and our advocacy around that was I learned that basically if you're not an American citizen, your privacy rights at the very least are basically non-existent. So if they were to take your phone or copy everything, like clone your hard drive, here in Canada at least, we'd have a lot more rights to maybe try to get at that. And apparently American citizens have some rights under their privacy acts, but their privacy laws are pretty weak compared to ours and certainly discriminate, even if it here, at least, like if our privacy laws aren't as strong as we would like them to be in Canada, but at least they don't discriminate against whose phone is being searched. So, so I guess that's the most I can offer, but I have absolutely no idea. I don't know if any of my colleagues would either. The thing is, we're just not, we're not trained at all in American law. And we're also subject to the same, I think, media about the Americans and how much they've fortified their borders now, that I would just think we might need desperate measures. I don't know. I would think it would be a pretty bleak situation, but probably not as bleak as if we were Mexican. Again, I'm speculating.
Thank you, Megan. I think we have a couple minutes. So there's another question that has come through that I'll pose here. Maybe this one could be for Ga or Veronica. What can a group in an Indigenous community do who watch helplessly as finance groups and corporations that come in and manipulate their leadership?
Okay. What I can say on this is, like, I think it's important to contextualize this question. And like, part of colonization was deliberately to impose colonial ways of government into Indigenous communities and take away from the Indigenous governance and traditional legal orders in Indigenous communities. So it's precisely because the colonial government wanted to be able to influence and have control and take away from the way Indigenous communities have traditionally governed themselves, that we come up with this structure that is the colonial structure of the Band Council. And I think it can be really challenging for communities to when this kind of issue comes up, and it can be really divisive in communities. And like, colonial structures can be more vulnerable to corruption, I think, because they can lack certain kinds of actual community consensus building processes, that kind of stuff. So I think it's important to make sure that we're reflecting that when it comes to band councils. So what can people do? I think I think that it's important to really work together as a community. I don't know that I can speak so much to the actual advice part of it, but you know, everyone does have a right in their community there's democratic rights that we have within Indigenous communities. I'm saying we, but I'm not Indigenous, so I apologize. I just mean in general. You have these democratic rights in your community, and you have rights like your government has a fiduciary duty to the community to make sure that they are acting in ways that are in the best interest of the community and being transparent and accountable. So I would really encourage people who are concerned about that to engage with their community and build awareness and consensus in their community. I think that this is a challenging area where there can sometimes not be a lot of resources available. So to support groups, but I certainly encourage the truth seeking and exercising your democratic rights in that context. And hopefully we can start to see more allyship with Indigenous communities who are speaking up against this kind of corruption in their government. I hope that was somewhat helpful.
Thank you, Ga. So this concludes the open question portion of our panel discussion. And before we wrap up, I'd just like to say a big thank you to our panelists and everyone working behind the scenes to make this event happen. And if you like this, follow us on Twitter, Facebook, and sign up for our email list at bccla.org to stay informed on our future programming and the work we're doing. And if you would like to donate to the BCCLA and help us keep our work ongoing, there's a link in the chat that will bring you to a donation page. So thank you to everyone who's joined us here tonight. We hope you found it informative and empowering, and have a great night.